My name is Gregg Banninger. I'm the Innovation Manager of Life Sciences at Rainforest Innovation. I'm also a registered patent agent. Just a disclaimer that in my experience in university, we often don't go fully in-depth prior art searching. We do a little bit, we just don't have the time to do it. But for your company, especially for investors, if they're going to invest a lot of money in your business or your technology, they're going to want a little more fully in depth, and there are resources to do a really deep dive of it. I will cover a lot of some of the basics and some of the more deeper dives, but just a disclaimer that in my experience, I never really dug really far deep into it. And if you're really doing a full prior art search, it probably could take a day or even more of searching to be satisfied fully with your search results. So to start, I'm just going to start. The first half of the talk is just cover some of the basics of patent law. You have to understand what the patent law is to know what you're searching for in the prior art and how your invention needs to be different than what's out there in the prior art. So there are four main types of intellectual properties. The bulk of this talk is going to focus on patents. There are also trademarks. These are for I'll cover that in future slides. You got trademarks. Copyrights are works of art created, of writing, music, movie. And then there's trade secrets. We typically don't deal with trade secrets in a university setting. It's only protected by keeping it secret. So for trademarks, these represent any word, name, symbol, or device or combinations used to identify a source of goods and services and distinguish the goods from others. We're all familiar with some of these typical trademarks for Starbucks, McDonald's, Nike. One thing to note is just using something in commerce will give you trademark on that in the region you're doing business. But if you wanted to do if you wanted to get full protection country or international wide, you would have to register that trademark with the USPTO. In order to get a trademark, you have to use it in commerce. You could apply for a trademark. And then after several years, you get some extensions, but you have to show you're using it in commerce. So it has to be like on a business website. You have to be selling a product using that brand name. And if you don't use it in commerce after your extensions are run out, you have to drop it. Another unique thing about trademarks is there's no such thing as prior art in trademarks. Either someone holds the trademark for it or they drop it and it's available for somebody to pick in. So let's just say for some mistake, McDonald's dropped their trademark yesterday. Someone can swoop in and get a trademark on that and likely would be very rich for that if that happened. Another comment about trademark I want to make. I'm going to switch out of my talk for a second just to show you since we're on trademarks, and this is the only time I'll talk about trademarks, I just want to show you where you can do a trademark search, or at least a basic trademark search. So if you go to the uspto.gov/trademark search, you can come on this page. You say search our trademark database. Now, typically I've never done a search where you're looking at an actual design, so I wouldn't know how to like a symbol, like the McDonald's symbol. But just basic word searches is what I've done. You go on to basic word search, and let's just say McDonald's. You submit the query, and it'll give you a whole list of McDonald's. So you'll notice there on this website, you will see that your status is live or dead. So dead means that one's no longer in use, they've dropped it. Live means it's still active. As you can see, there's a lot of different McDonald's in here. Another unique thing about trademarks is you can have multiple trademarks to McDonald's. They're limited to the field of use that they're used in commerce. So no one could get a trademark for a restaurant called McDonald's because it's in the same area as the McDonald's, the typical burger joint McDonald's, but you can get trademark to McDonald's for other services that are outside of this. So you can look and you click. This is probably just a typical. Okay, so this is McDonald's trademark. When you click on it, you can see what's restaurant services. So it's goods and services specific. And then if you like go back to, let's just say, well, we know Ronald McDonald's House. I don't know, BR McDonald's. Oh, that was abandoned. What's a live one? Okay, so here's one that's McDonald, but it's for real estate development and construction property. So that's allowed because it doesn't confuse someone to think that this McDonald's represents a restaurant. That's allowed because it doesn't confuse someone to think that this McDonald's represents a restaurant. Okay, so I will go back to my presentation. Okay, so the next is copyrights. I'm not going to talk too much about this. Copyrights are creators' rights to the original work of authorship. You don't necessarily have to register your copyright in order to have protection. Once you create something, you automatically have a copyright to that.
Can't believe they did this.
And this lasts for either the life of the inventor plus 70 years, or if it's a work for hire, like say you work for a company like Disney and you create something, it's a little bit longer than that. It's 95 years from the date of publication or 120 years from the date of creation, whichever is shorter. If you want to enforce your copyright, you have to register it. That's the time when it comes to registering. And I think it's a pretty fairly inexpensive and easy process to register your copyright. Trade secrets, not something we typically deal with at the university setting, but can be valuable as long as you can keep it secret. They're really, if the secret gets out or someone reverse engineers something, you don't have any recourse like you would if you had patent protection of something. So the big thing here is to keep it secret. I think only if there was the result of industrial espionage would you be able to recoup losses for losing your trademark. This can be very useful in a company, particularly maybe software where you don't want people to try to copy your software or work around your software patent if you were able to get one. Maybe you just want to keep your secret sauce in-house and not let anyone see it. That can be valuable there. I know in the university setting, we typically do not deal with that because the whole idea is to publish and share the knowledge with the public. The bulk of this talk will deal with patents. There are 3 types of patents: utility patents for new useful process machine manufacturers composition of matter. There are design patents. This solely is for how something looks. You can't get a design patent if what you're claiming is functional. And there is definitely value to this. Apple, for the longest time, most of their patents were design patents. There's been some big infringement lawsuits between Samsung and Apple over the curvature of the app icon. Apple had a trademark, a design patent on the way that looks, and other phone makers were using it, and there's been court battles regarding that. And you can also get a plant patent. These are very specific to the exact plant you made, and they need to be distinct and asexually reproduced plants. The bulk of my talk, we'll talk about utility patents. I don't think I've ever had to do a design patent. There's a lot of image searching, and we don't typically get any kind of design patents in my experience at the university. So what rights does a patent provide? The only right it provides, it doesn't provide you the right to actually practice your invention. It gives you the right to exclude others from making, using, selling, or importing the patent invention for a limited time. And this is 20 years from the filing date. Now, I note that you can have a patent and you would not be, and it's possible that you wouldn't be able to practice your invention because you're infringing on another patent. So I'm going to give you an example that I just made up in this case. Let's just say company A has a patent claiming a very specific antibody used to treat cancer. However, company B owns the patent that was used to make that technology, and company C has a broader patent that covers your antibody as well. So in order to be able to practice your invention, you would need to get the rights to those, which tend to happen with a license agreement from those companies. So this is why it's very critical to do a freedom to operate analysis. Now, my talk is more focused on prior art searching to see if your invention is patentable. It can be relevant to freedom to operate, but the freedom to operate will probably be a lot more in depth. And that's something that if a company wants to license your technology for lots of money, or you have a startup company and you're looking for investments, the investors will want to know if you have freedom to operate. So it'll be very critical. This can be done on your own, but I would suggest if there's going to be lots of money involved, it would be done professionally. Either you can have it done by an attorney; they tend to be more expensive, or you can have it done by their companies that specialize in doing freedom to operate and prior art searches that could be more affordable than the rates that an attorney would charge. I forgot to mention previously, but if anyone has any questions, I'm fine if you want to undo your camera and chime in and ask it, or wait till the end, or pop something in the chat and we can address it at the end. But feel free to interrupt if you have any questions while I'm going through this. So just the 4 requirements for patenting are, the first one is it must be eligible subject matter. So it must fall under a process, machine, manufacture, composition of matter, and any improvements thereof. I won't go into too much detail about this, about what falls as eligible subject matter. There's been some changes over the years. Some things that may recently started to may cause some issues falls into these judicial exceptions, laws of nature, natural phenomenon, and abstract ideas. It just makes it a little more challenging and have to overcome this rejection. Software falls into that category. It's considered an abstract idea, but they're figuring out better ways to get around that issue. I think the thing that took the biggest hit is diagnostics. They consider that to be just looking at a natural phenomenon, even though it takes a ton of work to do that. And it's very valuable. Like the future of medicine revolves around tailoring your treatment to your genes, your biomarkers, markers that you have inside of you to personalize medicine to you. And the way that they determined you are able to get around that is a little bit problematic, is that unless you come up with a completely novel way to detect biomarkers, which most of the time is standard detecting DNA, detecting mRNA, antibodies detect proteins, they're all pretty much standard techniques. So unless you have something unique above that, or you link it to a treatment step, then it can fall into this one-to-one rejection. The problem with the treatment step is that in order to infringe on a patent, you have to perform 2 steps. And if you have a diagnostic and someone's selling a diagnostic kit and they don't tell people how they're supposed to treat, they just sell the kit, they're not infringing the patent because they're not the ones administering the treatment. So it definitely is problematic. But lower court cases over the year are working on dealing with this problem, and even the courts below Supreme Court have noticed the issue that this SCOTUS ruling has made, but they're kind of bound by the Supreme Court. It must have credible utility. Most inventions obviously do have utility. I think it's an example here. This was a patent application for a warp drive. It didn't really have credible utility because this technology doesn't exist. So that's one example there. The next requirement is you must teach and adequately describe the invention. There are 2 kind of forms to this. There's enablement. So someone of ordinary skill in the art in the area of the technology must be able to see your patent and be able to make it use your invention. The other thing is any claims that you have or future claims you write in the application, and I'll discuss that in future slides, what claims are. They must have support in the specification. So the idea here is you have to actually show you invented something. You can't get a patent on an idea, just coming up with an idea, and you haven't shown that it works. In the engineering spaces, you don't have to have made something and have data on it in order to get a patent, as long as you have scientific drawings that show that this would work. But in life science areas, you will need data to support it. And if you don't have that, then they won't allow you to get those claims for lack of this 112 requirement. The requirements that are fitting for prior art searching, the first one is the 102, novelty. It must be novel and not publicly known. the term prior art is basically anything that's known in the world post the first filing of your invention. So when you file your invention, anything prior, anything prior to your filing date is now couldn't be prior art against your patent. Anything that comes out in the future, not so much, because as long as your patent is solid and you have enabled it for it, and I'll discuss that in future slides as well. So what's publicly known? Typically, examiners will pull things that they can tangibly cite. So those will be publication, patent applications, web pages, anything that's kind of you can cite. But it's not just that falls into prior art. If you offer to sell it, if you use the invention in public and someone can determine it enables them to do what the invention to know what the invention is, that could be considered prior art as well. For the most part, a lot of the prior art searching will focus on what's available publicly on the web, in print, in scientific papers, and patent applications. One note I like to make with this, it happens a lot in university settings, is that you may discover a new property of something that was known to do something else later on. You've discovered a new property. Just discovering the mechanism of action doesn't allow you to patent that, unless that mechanism of action allows you to treat a completely different disease that maybe the prior compound or invention used. And I use disease mainly because my area is life science, so that's I'm more familiar with that compared to the engineering space. So just a note on novelty. For novelty, the prior art must teach everything in your invention. Now, oftentimes people might make something that there's something in the prior art very like it, but not exactly like it, and they added some additional elements to it to make it different. So it wouldn't fall under 102. But if combining those references to come up with invention gives expected results, you can get an obviousness rejection. So, this example I show here is a little ridiculous, but let's just say these two inventors, this inventor had a patent on this device here. This other inventor later on tried to patent it where he added this tassel. Let's just assume that's functional and maybe it's used to carry it or something. He wouldn't be able to get a patent because it would have been obvious to add this carrier element to this invention. So typically, these non-obvious rejections, you'll have one art that cites the bulk of the invention, and then the additional elements that you add on will have other arts. Will have other references to cite it. This is probably the most frustrating for everybody, a patent practitioner as well as the inventors, because it's very subjective. What one person thinks is obvious and another person thinks it's not. Later on, I'll go into some ways to think about how to overcome these rejections, and it's important to think about when you're coming up with a new invention, how you might address future obviousness rejections you might see. So I just want to show here, here's an example of a patent publication. In this case, this is an issued patent. You'll notice, I think we're up to 11 million now, maybe 11 million, or we're definitely in the tens, but I might be approaching 11 million. So every time there's a new patent, it just gets another number. So in this case, at this date, there was 8 million patents in the US, issued patents. If you see a publication number up here, or if you see a number like this, you'll know that it's a publication. So it's not necessarily an issued patent. And typically it'll be a number like US, the country, the year, and then a bunch of numbers that represent the publication number. The front page of the patent could have a lot of useful information, particularly when you're doing prior art search, which I'll cover down later on. Some important information is assignee. So assignee is technically the owner of the patent. So any researchers at UNM, they are obligated to assign to UNM, and then UNM assigns it to UNM Rainforest Innovations. So essentially that makes UNM Rainforest Innovations the owner of the invention. If it was not assigned to anybody and there were just these 3 inventors, each inventor, at least in the US, each inventor has equal rights in ownership in this entire patent. Another bit of information, you'll see the application number. I could show you later on why that would be useful if you want to go into a patent pair, which I'll show you. The filing date, it has some, prior information. Another thing is the priority date. So, this priority date is when you stake in the sand your invention, and anything that comes before you, anything that comes after that can't be used as prior art. So that date's very important to know. Whoops. So that date's very important to know. You can see here classification codes, and I will go into the importance of this in classification searches in the future slides. Also reference cited by the examiners. So this was stuff that was considered prior art against this patent, or it could also be references cited by the inventors. Basically, in the US, you have an obligation to disclose prior art that you're aware of. And if you don't, it could potentially invalidate the patent. So anything the inventors or the applicants submitted would also show up here. This can be useful when you pull up a patent, you want to look for additional prior art, and I'll touch that on future slides. It tells who the examiner is. One interesting thing is there a website from attorneys that kind of explain the tendencies and grades of the examiner.
Hello?
Hello? Someone have a question? Okay.
Hi.
So just covering parts of the patent. Basically, everything in a patent is considered the specification, and everything in there is there to support the most important element of your invention, and that is the claims. Claims are at the end of the application. They basically lay out your property lines. Examiners search based on the claim, and everything else in the patent, all the writing, all the figures, all the drawings, they're all there to support the claims. And one thing that's important to think about when drafting a patent is you don't really know what the future claims will be. You don't know what the prior art is. You might have to change claims. You might want to add claims. So one of the skills of a patent practitioner, an agent, or an attorney is, having enough in the specification to support something in the future that you don't know it's going to happen. Because basically, when you have a patent, you want the broadest possible claims you can get to prevent people from infringing on your product or working around it. But you don't want to have it too broad where it's easy to invalidate it later on. So I just showed property lines to kind of represent intellectual property lines. Obviously it's a lot more complicated because the property lines are written in words, so it's a lot less easy to define than a map. But basically everything, all the claims that you're allowed to get, all the property lines you're allowed to get depend on two things. What do you have support for in your application, and what's in the prior art? Typically when you first file a patent, you might have claimed really broad property lines, but during prosecution, you had to narrow it because of the prior art. Your own work can be prior art. We tend to see that often where, especially in the university, we have a patent, it gets published, it's publicly known, and then there's improvements later on where the old stuff eventually becomes prior art. So that could be problematic at times. And eventually your own work will be cited against you in future things, and there are ways to work around that. I always put this up here. It's best to keep, until you file a patent, it's best to not publicly disclose it. The US is the only country in the world that gives a 1-year grace period. So if you publicly disclose or publish something, you have a year to file a patent. Only you can file it. Nobody else that's not part of your group can file it. So it's often best to file something before you publicly disclose it. Just some brief patent filing options. The typical process is in the US. The US is the only country that gives a provisional. It's kind of a 1-year holding place. It does not count on your 20 years, so it gives you an extra year of protection. It allows time to make improvements, and you can file as many provisionals as you want throughout this year, and then combine them all together into a full filing. You can either just go US only, or you can file what's called a PCT, or Patent Cooperation Treaty. This allows for the ability to patent it worldwide for the most part. Every country that's in the PCT, probably any country we would actually want to file in is part of the PCT. It's more expensive than filing in the US, higher filing fees. It gives you 18 months until you have to choose which countries to go into. And then you can see this gets really, really expensive because you got to pay your US attorney to provide instructions to the foreign attorney. There's all kinds of filing fees in these foreign countries, and it can really add up quickly. You could file a PCT directly. You could file a US application and then a year do a PCT. You can use a foreign filing application to be used as priority for a US application. So there's many different options, but here's the typical pathway that most of the time is followed. I mentioned earlier, there is a risk to, let's just say you come up with an idea, but you haven't shown it worked, and you file a patent, but it's not enabled. So you haven't actually invented anything yet. And then maybe in a year later, you make improvements, and now it's enabled. So you technically would not get this priority date. So if there was prior art from somebody else that falls within this year around your work, or even if possibly you publish it yourself, that's new from what was here, you won't get priority. So it's not just good enough to say, I have an idea, I'm going to file a patent, and then I'm going to have priority for that. You're not guaranteed that if you don't have support. And oftentimes this becomes problematic if, years down the line when you're doing patent prosecution, you change the claims because maybe your business model changed or the prior art determined that. And maybe your initial filing didn't get the priority date. So your priority date is a year out. Things that fall in here could be used against you. So just one thing to keep in mind. Just briefly, the patent process can be pretty costly. I think on average, it's about $25,000 for US. When you start going into multiple foreign countries, it can get up into hundreds of thousands really, really quickly. The first process is drafting the application. This is a collaboration between a patent attorney or agent and the inventors. Then typically, it depends on the art unit. Typically you probably won't get it seen by an examiner for at least 2 years. It can be much longer in certain art units. I'd say on average, it's probably about 2 years before you get your first patent prosecution. But typically once it happens, it moves quickly because it's fresh in the examiner's mind. So when you respond, they respond back pretty quickly. Patent prosecution is kind of back and forth in writing between you and the examiner and the attorney to argue that they'll reject claims or object them. You make corrections or arguments, and then you go from there until hopefully you get your patent issued. The patent issue doesn't mean you're in the clear. Someone could later on try to say it's not patent eligible and go to the courts. The courts have a different standard sometimes than the USPTO, which causes issues and allows for patents to be ineligible later on. So just having it's strong to have a patent issued because infringement lawsuits and trying to challenge eligibility are very expensive. So if someone wants to take you on, you have the patent behind you, but that doesn't mean you're fully in the clear. US has maintenance fees every 4 years that double. Most other countries, from the time you file it, you have to pay a yearly annuity. Of course, over time, it keeps going up and up. The most expensive one tend to be Europe because Europe covers a group of, I think, 30 countries, around 30 countries in Europe. So you get prosecuted one time, and then once you get through that, then you go into the individual countries that you want. But you can see they also have high fees because they have to spread the money out to the other countries as well. So this is relevant to when you do prior art searching, things to think about. Obviously, the best way to overcome a rejection, the easiest way is if your property falls into someone else's property lines, to just move the property lines. And how do you do that? You amend the claims and narrow the scope of the invention. Oftentimes you may file a patent very broad, and then you get all this prior art that doesn't look anything like your real invention, like the very specific invention. And it's only because the examiners are reading the claims as very broad, and that reads on these things. So you'd have to adjust that. Arguments by attorney are often used, like maybe that the invention, you can argue that the examiner is misreading the prior art, they're misreading the invention. Sometimes this works, but there's not a lot of weight to it unless you back it with evidence. So if you just make an attorney argument, the examiner can just say, I respectfully disagree, and then that's that. But if you cite either another publication or you submit a declaration from the inventor to make the case, now the burden shifts to the examiner where they have to find evidence. So it's better to submit evidence along with your arguments to overcome the objections. This will be very important. There's a lot of stuff out there. There's a lot of prior art. Your invention might come close to something out there. You'll likely face, I think every patent will face an obviousness rejection. It's almost like a given. It's rare that something is so novel out there that it doesn't touch anything and it gets issued right away. We rarely see those. Most of the times you'll get at least one rejection, possibly at least 2 or 3 or more. So some of the ways to argue obviousness is commercial success. That's something we typically don't deal with because in the earlier stages, we don't have it in the market yet. Large unmet need, that's a strong case. If someone's been trying, this has been a problem for 20 years and no one's done it. How is it obvious, my invention, if no one's done it in 20 years? The thing that carries the most weight is unexpected results. I like to give an example, like let's say you have a known cancer drug and another known cancer drug, you combine them and you get maybe a doubling of the results. That would be expected results. But if you see something just off the charts, complete cure of the disease, and you have the data to back it, then it's unexpected result and it's not obvious. So data is very important. And one of the good things with the US at least is you can submit data that was collected after your priority date to support your arguments in a patent application. And oftentimes we have to rely on collecting data and submitting data to get over an obvious rejection. Failures of others kind of goes to a large unmet need. Many people have tried this and it hasn't worked. So how is it obvious? No one can do it. Teaching away from the invention used to be used a lot, where if someone said, oh, this couldn't be done and you made it work, that works. But this day and age, there's so much information out there. It's likely the examiner could find something that says it can work. So the best thing is unexpected results. There's importance of negative data as well. Like let's just say you have a particular sequences where this particular one worked very well, these didn't work, and the prior art was addressing maybe a bigger area of your patent, and this doesn't work and this doesn't work. So it's not unexpected results. It would be unexpected results that all these things wouldn't work based on what was known in the art. So just keep that in mind, that the data collection, even after your submission, can be very important, and negative data can also be useful. Another thing to think about is, you tried to combine these two things, but you had a lot of trouble doing it and you had to work through all these issues to get to it. So it can't be obvious if you had to problem solve and fix things to get to that. So these are all things to keep in mind, particularly when you're doing your prior art searching. You really want to know how your invention is different from what's out there in the art. So now I will jump into the prior art section, searching section of the talk. So benefits of conducting a prior art search. Obviously, you don't want to spend a lot of money submitting a patent application and then find out later that they're not patentable and you just wasted your money. Same with a company. If you invested money or you got money invested into your company, based on the idea that you would have a patent on it and then you don't get a patent later on, that could be problematic. You want to determine the novelty of your invention compared to the prior art. It also helps in a business sense to know what's out there, where the competitors are. And in your prior art search, you can identify that. You can also identify how much better your product is. Now, that's not really relevant to prior art searching, but it is important for a business to know these things. Even if you can get a patent for a technology, you still have to penetrate the market and be better than what's out there and what's being used currently, and enough to justify a change or maybe an increased price point. It also helps develop a strong claim strategy before we file a patent. I mean, typically in ours, our attorneys do not do a deep dive prior art searching. I'm sure attorneys that are in-house at these big companies that have lots of money, they will do that and they will gear their claims towards it. We tend to do a very broad and then narrowed down approach. But if you're aware of prior art, you might as well just, you know, draft the claims to make sure you get around that prior art. You know, knowing the prior art and what's close can help you guide your patent drafting as well. Helps understand how your technology fits into the field. We kind of mentioned that in my previous comments. Be better prepared to discuss the invention with the attorney and better explain patentable aspects. The inventors will be key in explaining their invention to attorneys. The patent attorneys are, you know, most of them will have advanced degrees in technical areas. Maybe not be experts like you are, but they're just broad area experts where they can cover a whole bunch of things. Obviously, they're experts on filing patent and patent application. They'll be able to understand it, but it's very important the inventors educate the attorney on the invention because you guys are the experts. And as I mentioned earlier, freedom to operate and knowing the competition is also very important. So some of the key points, and I'll dig deeper into each of these in future slides. Some of the key points of doing a novel search, I think the most important thing is understanding your invention, understanding your property lines. What are the structure, function, how do the elements interact with each other? I think it's very important to envision what you would sell. So let's just say you come up with a novel microscopy device. Now, is it a full brand new microscope, or can it be an add-on to existing microscopes? And if it's an add-on to existing microscopes, you'd want to claim that. It would be very important to claim that because somebody would be selling just the add-on. So just things to think about. Obviously, businesses change, and you maybe want to cover multiple potential products. And I'll explain later. Later on, you can add additional claims, and I'll explain how you can do that as well. One thing is important. If your invention is a device, the biggest important things is going to be the structure, and not so much what it does. What it does will help, obviously, but when it comes to claims, you're going to be claiming the structure, and that structure may read on other things that do a different function. So it's just important to have that distinction between what are the elements, how they're arranged, especially if you're dealing with like a device, and then what it does. And what it does is important, and it'll be important for dealing with obviousness rejections and obviously for the commercial aspect. But ultimately, the examiners will search claims. So just keep that in mind. Sometimes, I think when I first started putting these prior art searching things when I was at the University of Illinois, our interns would do prior art searches, and they focused a lot on function and what it does, and they did their prior art searching that way. I'm like, you're not going to find the structure by doing that. Search terms. Ultimately, there should be all kinds of, you should have like a whole long list of keywords, combinations of keywords that you used. There'll be multiple variations to consider. How they're ordered if you do multiple, if you just don't do one keyword, you do like a sentence or a paragraph. How it's arranged in the order, you might want to switch the order, how it's arranged can affect it. Are there any synonyms, plural versus singular? Is there issues with, English, British English versus here, things are spelled differently. And I'll dig some more into that in future slides as well. Basically, the term should evolve as you're working through your prior art search. So you may start with some basic terms. You see what's out there. Based on that, you might find new terms that you should use in search. So it should be a process of searching, coming up with new keywords, searching, and kind of working that way. That's kind of where it's an art. It's not just say, hey, here are my keywords, I'm going to search and I'm done. No, it can go on and on. search multiple sources. I'll discuss and show you some of those sources. You have the patent databases. You can search scholarly articles. I know in the life science area, there's PubMed that you can find publications for. General web-based search. And if you have a subscription like we do to a database, those tend to be really good for doing prior art searches. So just to get to the point, understand the invention. How I typically, when I get a new invention disclosure, I think of it of first line is what's the problem, what's the solution. This can help with classification search, and I'll discuss that in another slide. What is the main idea behind your technology? Why is it necessary? What was already existing prior to this, and what were their shortcomings? How does this improvement? What part of maybe if you had a device, what part of it gives you that function that was shortcoming in the past? How does it work? Find all the areas where the invention could be useful. You may search, and your invention may be used for this, but there might be also some prior art that's in a completely different area that's the same device that maybe does something different. So I might read on the prior art it might be prior art to your thing, even though it's in a completely different area. Think of other ways of doing what the invention does. This also helps when drafting a patent application, because you want to think of alternate embodiments. So, let's just say your device uses a certain material. Now, maybe that material is critical, but you got to think what other materials could be used, because you don't want to get a patent for just one material and someone has a different material, and now they're no longer reading on your patent. What is the invention? So does it fall under composition, a method or process, a machine or device, or an apparatus? Pretty much a device tends to be things with moving parts. Apparatus, not so much like a crutch or a pencil. That's the difference between the apparatus or device. I will admit method claims are notoriously hard to search. They're hard to enforce. How do you know someone's using your process? If it's hidden, you don't know. Even the patent examiners have issues searching for method or process claims. So, when I see a new invention, if it's a device or apparatus, what are the components? How are they interact with each other? What functions do they perform? If it's a method claim, what are the steps? Are there any steps that are just things to think about? Are there any steps that are optional or absolutely necessary? If it's an optional, you might want to not get a claim that has that in there. If it's optional, you can add that as a dependent claim, but you want to get the broadest coverage you can think of. I think this helps kind of outlining your invention and on all the components helps you know what your property lines are and know if you are invading other people's property. So the more you better understand your invention, the better prior art terms you will have, and the better idea of what prior art out there reads on what you have. So examiners search based on the claims that you have written. So having an idea of what the claims could be, you don't need to be a patent practitioner to do that. You can kind of lay out an outline. I kind of hit on this point. Structure, function are different things. If you're trying to find prior art on a device, you may want to search more on their structural elements versus the function, what they do. You could do both. Obviously, what the invention does is very important for the commercial aspect because that's what you're commercializing. I'm going to go through some examples here of, so this is just a basic chair. Now, typically when I get disclosures, I have the problem, solution, maybe read through it. I'll take some notes. Obviously, if you're the inventor, you already know what those things are. And then I work on an outline of what do I envision the claim could be. So, in this, I'm just showing an example of kind of the questions you would ask. Let's just say the invention is a chair, three-legged chair. So, what are the components and elements of the invention? We have a chair with 3 legs, a seat in the back. How are they arranged together? Well, the legs are attached to the underside of the seat, held together by nails. Something to think about. Maybe in this invention you did nails, but there are other ways to connect them. Are the components necessary or optional? So just that's more like thinking like a patent agent, where in the claims, you might want to have a broad claim that lacks a back because the back is not needed to have a functional chair. And then a stool could be sold and not infringe on your patent. This can come later on. That can still be claimed, but not in your broad claims. And patents are tend to written very broad, and then they get narrowed down to like the exact point, the exact invention or embodiment that you may have. It's also at this point, what are the think of alternative embodiments? Can it have more than 3 legs? Yes, it can. So maybe in your outline, you wouldn't want to think about just having 3 legs. So, if you go through this process with your invention, now you kind of come up with an outline of what a claim might look like, an apparatus for sitting. And what are the components? A seat, 3 legs, a back. And then I tend to just take notes. What is it made of? This one's made of wood, but there's probably no limit in the material. So in a patent, you would have a whole bunch of different materials in there. And, let's just say this is the outline. Well, now let's just say you turn those into claims, and this is how that outline would be turned into claims. And I won't read each one of these, but that's kind of the process that you go through, kind of understanding the invention. Obviously, when you're doing it, you're the inventor. You already understand your invention. So, approaches to invention outlines. Typically, we'll start broad, go narrow. Obviously, when you start your search, probably the narrowest you go, you'd want to search narrow right away, because if you find something exactly like your embodiment, that's it, right? But if you find things that are close to it, that might help guide whether you claim very broad or you claim just slightly broader than what your exact embodiment is. But you want to do searches of the general concept versus what the specific embodiment that you actually have is. I think this can kind of help guide your search parameters. I kind of hit on this in another slide, just what you're going to sell. It's important to have claimed what you're going to sell. So kind of think that through as well. So here are some resources to do prior art searching. Google Patent and Google Scholars is really good. There is a negative to that, and they sell your search information to other parties. So maybe if you're searching your invention, they'll sell it to somebody else and they'll come with you. I don't know, maybe that's a little far-fetched, but they're definitely selling your information. It's a great place to go if you want access to patents and PDFs of those patents. You just type in Google Patents those, like either the application number or the patent number, and you can get access to the PDF. And I'll show that, demonstrate that after I go through this list. DuckDuckGo is a way to search that doesn't sell your information. I guess the negative for me that I find is I'm not used to it, and I just like Google. But it's also not good to have them selling your search information to everyone. For life science, medical related technologies, you can search on PubMed. I forgot to mention Google Scholars, another thing that searches for academic information. I think if you're under either of those pages, you can click a button and search both Scholar, patents, and the publications. The USPTO website is a good place to search for US patents. There's also websites for like WIPO, the World Intellectual Property Organization, to look at PCT applications. SpaceNet is kind of the version of the USPTO website. It's the European version. And then there's paid data subscriptions. So I am going to, I want to demonstrate some of the important websites. So here I'm showing like Google Patents. So all you do when you go to the Google Patents is, put in the information you want, hit search, and now it pulls up that patent. Here you can what I like about this is it's searchable. Sometimes PDFs are not searchable unless you translate it into text. So if I'm looking for particular keywords, I can just, do a search and find everywhere in the document it is. That helps me focus on things if I'm looking for something that might be prior art. Another great thing is You can download, you can get a copy, a PDF copy of the patent from here. It also shows some of the other information and priority dates here. It's got all the claims. So it's definitely a great site if you want to look up patent publications and applications. Let's see, that's in my way. Okay, the World Intellectual Property, the WIPO webpage is kind of the same way. You can search a number of different ways. You enter your search term, you can find things that you want. You can, you can pull up PCT applications from this website, which I don't think you can get from Google Patents. You have to go here for it. There's another useful thing on the WIPO website is when you file a PCT, you get a preliminary search report. So you kind of get it's not a full-on examination, but someone does some prior art searching for you, and an examiner in one of the, or whatever country you tend to select. Some are more expensive than others, some are more in-depth. Europe is probably the most expensive, but also the most in-depth. US is probably the second best one. And there are some that are much more cheaper, like Korea, Russia. Maybe it's not as in-depth, but it's definitely more affordable, a lot less cheaper. And they'll provide some references and kind of give you like a preliminary office action type of thing. You can get that information as well when you pull up a particular patent here. I don't think I ever really go to the European version, but the SpaceNet is kind of the USPTO of Europe. So you can search and find European documents and stuff there. We have access to a patent searching database. Now, this is a pretty expensive fee that it probably won't be available for everybody, but this is typically what we use. There's a lot of really cool, some I don't even know yet because I don't really go totally in depth too much into prior art searching, but there's so many things here. You can do keyword searches, multiple combinations, and an or tend to be very important, or not. If you want to exclude something, that's also important. I believe you can do that also when you search in Google, but I don't think I typically just Google phrases or keywords in the Google if I ever do, or DuckDuckGo. Here's a nice one, semantic. You can kind of copy and paste, maybe a summary of the invention in here, and it'll search through that. That's kind of one of the nice things I like about, the DuckDuckGos and Googles is, you put in a phrase that covers what you think is the invention, and it usually finds it pretty well, as opposed to just doing individual keywords. Not everyone's going to have that access. Let's see, there's one other thing I wanted to show. So everything that's been published in the US is available on public pair to the public. So I'm going to put this patent information into this website, USPTO public pair. Just notice that the website is terrible and clunky, and you might oftentimes have to either make sure you don't have spaces, or you're missing commas or certain things, and sometimes it just doesn't work. So I do it multiple times to get it right. See, I know I entered it correctly because I saw it earlier, but this is the kind of stuff you get. Let's see, 1, 2, 3. Now it's probably not going to work while I'm here. There we go. So if it fails, keep trying for a little bit. It's very a clunky website. I don't think it's really been updated in many years, but it's very useful information. So when you pull up a patent or a patent application, you get all this information about what its status is. You could pay and check fees. It's a whole bunch of information, but one of the things, let's look at assignments, who owns the patents. But one of the valuable things is you get to see the entire patent prosecution. So I typically sort this by the date. So you get the whole history of everything that was ever submitted. If I want to look at office actions, like why was this rejected? Why was it allowed? You could pull up all this information from here. You click and then you get a PDF downloaded. If you want to see what prior art was cited, that can be very useful. So I'm oftentimes checking into pair, even for our patents. It's just easier to get this chronology of everything that was ever submitted. And typically, I'll go look at the claims. How did they amend the claims? What was the prior art? That can help you find prior art that was cited against something that was related to you that could be used against you later on. Okay, so there are certain ways to do patent searching. The most common one that we do and most people do are keywords, combination of keywords. I have a slide in the future that goes into all the different types of things to look into in keywords, so I won't cover it here. You can look, you may know a company or a competitor might have something like your product. There might be prior art, so you might look for them. So you just search for assignee or the inventor if you know it's an inventor. You can do a classification search. I'll cover that later on. Basically, technologies are broken down into large areas and then narrow and narrow embodiments. So if your invention does this very particular thing, you'd want to search for all the prior art that's in that very specific area that does the same thing. That's why knowing what the problem solution is important when you're doing classification searches. You may find a patent, you want to look what they cited. Remember I pointed out earlier that the cover page that showed things that were cited, that could be prior art against your stuff. You might want to look that way. One of the things I like about the PatSnap database is you can do forward and backward citations. So you can see what was cited by this patent and then who cited that patent. And I find that useful to see that if, this technology seems to be commercially relevant because all these companies are citing this patent. So they're working in that space. I do like to do that. So for prior art searching, start with your narrow, maybe move out to broader, because if say your invention is exactly this pen, there are many ways to claim, many variations that could be. But if this is your exact thing that you currently have, you'll want to search for this first, because if you find something dead on with this, then you found what you needed, and then you can expand out to broaden. Like I said, it's not a science, it's an art. It should be kind of a back and forth between starting with like limited keywords, maybe some top things you can think of, or combinations. Search that, see what you find. Maybe while you're reading that, you see different terminology, different keywords you can use. Use that to come up with new keywords and kind of go back and forth in that process for a while. Another important thing is think out names. Actually, I'll cover that in the next slide. I'll just skip that for here. And I already mentioned that public pair can be very useful to look at the prosecution history as well as look what was cited against them. You won't get access. You won't be able to access publications because obviously it's copyrighted material. The USPTO will not available, but you'll see the link and you can go ahead and get it with other resources. So for keyword tips, some things to be aware of: vague and inconsistent terms. Like if you're searching toy, that can cover so many different things. You might want to be a little bit more specific. How maybe obsolete names. Here are some things that might be Laserdisc, LP, high five. Nothing new is going to have those obsolete names. So think of other alternatives to how those are worded. Beware of different meanings in different fields. So a mouse can be the animal, or it could be, the computer mouse that we have. Think of synonyms. Use a thesaurus if you need to find different synonyms. Oftentimes, your searching will find different words that you can use in place of what you originally had. Some things to be aware of is hyphenation, no hyphenation. I tend to search both. Maybe the prior art hyphenates something, maybe it doesn't. Different tenses, plural versus singular, that could all affect a search. You might want to use both. I hit on this earlier, different British spellings. You might want to try both, because if it's a British article, attire might be spelled with the Y there. It's possible there might be spelling errors in the prior art, so it's not coming up. So maybe you'd want to search common ways that they may be misspelled. And I think there's some examples right here: repellent versus repellent and how it's spelled. Acronyms and abbreviations. So I tend to do both. I would search both the acronym as well as the full write-out, like so LED is light emitting diode. If it's a compound, I would search not only the brand name, if it's something that has a brand name, maybe there's a shorthand name for the compound that everyone uses, but I'd also search the full chemical, the full chemical, official chemical name as well. So think of those things. If it's a gene or a protein, I'll search both the shorthand, like, so if here's an example, TNF alpha, I would search TNF alpha, and I would also search tumor necrosis factor and spell it out. If it's a gene, I would also spell out the full gene as well as search the shorthand of it. So as you can see, you start building more and more keywords and combinations. Utilize technical dictionary or thesaurus to help you find appropriate terms as well. I think it's the best way to find new keywords is to look what you found when you did search, see how they worded things, and now try searching for that. Just some examples for prior art. So say you have some kind of new technology for a smartphone. Well, what are some keywords that could be used? Not everyone's going to call it a smartphone. It could be a cellular phone. It could be a mobile phone, smartphone. You may not find everything with that. So think of other things: handheld device, portable communication device. These are actually terms: portable communication terminal, wireless communication device. These are actually terms that would be in the patent claims. So, you may start out with cell phone, and then you find a patent and you see how they claimed it and worded it. Well, now you want to start searching the more legalese names for those, because that's what'll be in the patent and in the art, and that'll be searchable. Kind of hit on this, break down the invention in different parts. What's the purpose, the functionality, related application areas, what's the composition, what is needed to make the invention components arranged. These are things that could go into search. The last thing I want to go into, and I'll admit I don't have much experience doing this, but it's definitely something the examiners do. It was a pretty cool class. It was a program. Went to the USPTO in Denver for 3 days, where they kind of gave you a crash course on examiner training, so you get an idea of what they do, and they kind of went through how they did their searching and classification searches. It was very interesting. One thing to take home from that is how limited time they have to do everything. It's kind of amazing. So you can see why there can still be some issues with the examination process. Just they're so limited on time. So there are multiple classification systems. There's the USPC, the IPC, ECLA, that's in Europe. IPC is international, Japan, every country, region has their own specific thing. I think what a lot of people have changed to is the CPC, which is a combination of USPTO and the EPO classification areas. So it divides areas into subdivisions. And I think overall there's 200,000 different areas to look into. It's divided into 8 huge areas, and then in between there are subsections and subsections, as listed here. I will note I have a link here. A lot of this information, an example I got here, came from a presentation given by the USPTO. I was a little unfamiliar with classification search, so I kind of got some information there. So if you want to learn more about the classification search in more details, you can go to this link here. You'll also probably find it if you search. There's also tons of other resources online and YouTube videos of presentations on prior art searching that could be useful to you. So I'm going to give an example that they gave in this presentation. Let's just say your invention is an umbrella with a new rib design to eliminate umbrella collapsing and inverting due to high winds. This could eliminates the need to frequent replacement umbrellas. Kind of thinking through your components, framework for the ribs, stretch and mainframes, cure rings. These are some terms that you would come up from this. Some of your keywords here might be this. And obviously it would be a lot more than just these. But if you want to search try to find a classification area very specific to some of your components here, you can go to the website, the USPTO website. Here's the website here. If you go on the top and just click umbrella, it'll take you to another page that gives you a bunch of examples of areas of like umbrellas that would fall under umbrellas. So, you know, walking sticks, umbrellas. Let me see. Let me pull that up. Oops. Okay. So this will give you, for starters, when you search this, it'll give you what the main category A45B would be. And then you can go under the website even further, and you know, everything under A45B that relates to umbrellas is here. And you see very specific categories. Well, if you look at the one highlighted here, devices for increasing resistance of umbrellas to wind, that seems the most fitting to your invention. And then you click on that, I'll give you all the prior art that is in that area. I should note that one of the big selling points for classification search is that it goes all the way back to the beginning of the first patent ever. The Google patents, I think, goes to 1880. The USPTO website, I think, only goes to 1970 as far as the art you'll find, but the classification search will go way back to the beginning of the time of the country. I think when it comes to the highly technical technologies of today, it's likely you're not going to have to go further than the 1900s to find prior art. Probably would need a lot less than that, but there's one thing to take note of. I believe that is it for this presentation. I don't know if there's any, I'm looking at the chat now and see if there's any questions. If anyone has any questions, let me stop sharing my screen. Does anyone have any questions? You know, it's kind of no way to be I guess the best way to be a master of prior art searching is having done it, because, you know, it's experience. It's kind of an art more than a science. You can't just tell someone, hey, this is what you do. They just kind of have to feel it out. It's kind of a back and forth feel out process. I hope that gave you enough information to kind of get started.